send you more stuff than anyone else has ever received. Yeah. We'll make sure Matt does it. But speaking of the Indians, Ron, our teams played last night. Now,
I saw that.
Folks, last night, Ron is a big New York Mets fan. He is the one Mets fan in existence. Last night, I was waiting for Ron's text, actually, talking about how they just gave it to the Indians. What was the score, 9-2?
Yeah.
Right?
Yeah.
And I'm waiting for Ron's text. He's texting me about other stuff, but he's not bringing up the one thing, the elephant in the room that I know he wants to bring up. So I finally said, good game, Ron.
Yeah, Adam, if you're a lifelong Mets fan, you know never to jinx it, because the moment you feel confident, it's all going to come crashing down.
So I love when people ask us, is PACE better than a certified self-funding specialist designation? If you know me at all, you know exactly what my answer is. So, but I'm not going to say that answer. I don't want to get in trouble. Okay, folks, we will now bring it over to the survey questions. We have 3 survey questions. We're going to read them and then give you the answers to see how smart you are, especially in light of the fact that we just talked about PACE certification. So, first question that we got is, we ready to go here? Yes. Now, this is for anybody. Please don't ask us any questions about it. Do the best you can to answer this question. Across your entire block of business, so far in 2019, how many times have you seen a plan meet their aggregate deductible? None, 1 to 2, 3 or more times, or my favorite answer, what Brady would probably say, is what even is an aggregate deductible? Brady, do you know what that is? I don't think you do. I know all about DC, but I'm wondering if you do.
That's a very good Confucius answer.
So we obviously, so Berkeley's on the screen. Berkeley and every other stop-loss carrier wants to see the number 0 here, clearly. And it looks like, how many people have voted so far? A bunch? Yeah, we got a pretty good number here that have voted. It looks like, for most of you, it's been under 2 times, which is great. And I'm happy that we have that 7% of you who are honest enough to acknowledge that you have no idea what we're talking about. So we've been up there? Good. Next question. Be honest. When renewing a group for 2020, what's your primary concern? As a broker, TPA, even a stop-loss carrier? Just keeping the business no matter what, at all costs? Difficulty accommodating various programs and vendors, right? Making sure that all those vendors and all the different cost-containment programs make sense? Ensuring the group improves cost containment. Let's make that even better. Ensuring that they actually don't have a huge increase in overall healthcare spend, which is extremely hard to do. Last but not least, proving yourself as a worthy business partner. For me, folks, it's obviously D. I want to prove myself every day. I go home to my wife every night. I got to prove myself as a great husband. Right, Jen? That's what you want your husband to do, right?
That's right.
Every day, how lucky you are to be married to such a wonderful person. Now all these women are going to start texting me, which is fabulous.
As a spouse, I'm focused on containing costs.
Now, I love the fact that we still have that honest 9%, 7%, 8%. So we have the same people who don't know what an aggregate deductible is, are telling us, listen, I'm going to do whatever I got to do to keep the business. So it's the same folks, which is great to know. Ron?
You know, Adam, if you're not focused on cost containment, then you're going to lose that client. So I think keeping the client, pretty much encapsulates everything else.
Right.
There you go, 10%.
Okay, so next question, the last one. What is your biggest concern about reference-based pricing? Protecting the patient is no longer that. Defending the patient is no longer that, right? We know that. But here are the answers. The regulators will outlaw it, leaving the plan stranded. I think most of you saw what happened in North Carolina, where there was just not enough support from a contractual standpoint, getting actual contracts signed with the provider community, that the Teachers Association nixed the plan, even though I think over 400 providers agreed to reference-based pricing reimbursement. Second, member noise, confusion, and complaints. To me, that's the most obvious. Third, lack of an end game if providers won't settle. 2 and 3 are very similar in many ways, but I can see an answer to both. And last but not least, employer and employee misunderstanding of core RBP. Wait, tropics? Tropics. Folks, I think that's meant to say topics. My apologies. Brady has lost his job.
Somebody needs a vacation, apparently.
Tropics. That's all right. Employer and employee misunderstanding of reference-based pricing. Core topics. Biggest issue, folks, is clear. It's not about the regulators. It is clearly the member noise, lack of an end game, and misunderstanding. All that combined. So what do you want to do? It's pretty easy, folks. You want to work with the company, a vendor, and there's a lot of good ones out there who explains it properly, has training, has the right implementation, the right plan language, tells you how they're going to deal with member noise, whether it's a higher reimbursement level, whether it's ensuring good patient advocacy. And to answer that last one, lack of an end game, if the provider's not willing to settle, what are you going to do? Are you going to cave in and pay them what they want? If so, make sure stop loss agrees to reimburse at a higher level than the 150 you agreed to in the plan doc, maybe up to 200 or 250%. Maybe have patient defender on your plan to ensure that you have a patient defense, or you work with a vendor that already encompasses all of that. So, but it's pretty clear on that's 97%.
Yeah. And you know what? I'm really happy to see the responses we're seeing, because let's face it, if we don't address the angst amongst the employees and employers, that's when the regulators are going to kick in. If you address those issues first, the regulators won't be a problem.
Right, and we're talking about a bunch of stuff right now, so we're going to turn it over on the overview slide, if you don't mind. Matt, let's get it right there. And what are we going to talk about today in the overview? Problem, purpose, process. Last month's PGC's most frequently asked questions, brought to you by Jen McCormick. Compliance. All right, look at this guy, okay? I'll get to him in a second. Compliance, fiduciary duties. Speaking of Mr. Dangerfield, the opioid crisis. I mean, look at those eyes there. I mean, what is he on? Seriously, guys, what is he on right here?
Something's going.
I mean, that's not marijuana, I don't believe. Stop loss, PBMs, and adverse benefit determinations. Okay, next slide. Problem, purpose, process. Folks, what is the problem? Healthcare costs too much. What do we do here? We make it affordable for employees. Why? Because hardworking Americans deserve access to what, Ron?
High quality, affordable healthcare.
And that is the key. Add the word quality. Just because it's cheap doesn't mean it's good.
Right.
We got to make sure both. So with that, folks, thank you for these numbers to continue to grow. With that, I'm going to turn it over to Jen McCormick. Jen, let's talk about last month.
All right, thank you. So as we kind of dig in here, getting back to school, back to whatever it is that we need to prepare ourselves, July is the new January when it comes to getting ready for the upcoming season. So as we're talking about that, keep in mind that a lot of changes, compliance issues, a lot of regulations that have been coming out and that we're expecting to come out in the next few months that we need to prepare about or make sure that we can accommodate in our plans and our processes and our relevant policies. So first here, this is a question that we're commonly seeing. There was, if you haven't heard about it, a new regulation that addresses the prescription manufacturer assistance. So this was a regulation that is set to go into effect, a finalized regulation that is set to go into effect on January 1st, 2020. And this regulation, as it came out, is actually very, very narrow. There is some confusion, I guess, or ambiguity about the actual context surrounding the specifics, the background of this regulation, but specific to what the regulation actually says, it actually is pretty narrow in its limited scope for how and what it means for manufacturer assistance and talking about out-of-pocket maximums. So specifically, this regulation is letting us know that when there is a medically appropriate generic equivalent that could be available, but a brand name is actually dispensed instead of that, it is up to the plan, up to the issuer to decide whether or not that's going to count towards the out-of-pocket when that actual coupon for that drug is being used. So we know that there's going to be a limited purpose for when it comes to the specific regulation. So this means that as we're getting ready for 2020, it's time to actually look at how your out-of-pocket language is written and see if this is actually a caveat exception that you want to add to your specific out-of-pocket maximum rules so that you can accommodate this being potentially something that you want to adjust, exclude as far as counting towards the out-of-pocket maximums. But remember, this regulation effective 1/1/20 is specific to this brand and generic example. This is not necessarily something that is addressed on a broader level, specifically when it comes to coupon assistance or manufacturer assistance by HHS or CMS. So with that, I think I'm going to turn it back over to Ron so he can give us some updates about Subro.
Wow.
Wait a second. Yeah. Why is Ron getting to talk so fast?
I'm in PGC FAQs.
I don't think Ron,
look at me.
I don't think Ron has ever received a slide within the first 20 minutes of a webinar in like 3 years. Are you okay? Are you up for this, Ron?
So this is what it looks like.
All right, let's do it.
PGC FAQ. It smells so good here. So subrogation, the reason they brought me in is because, Subro is still sexy, and when it comes to sexy Subro, you bring in the Ron man. a lot of questions are actually coming in, and it's interesting because we used to address this issue, Adam. I don't know if you remember, like 20 years ago, right? The issue of contractual versus equitable subrogation and getting subro rights in writing. And it died down for a while, but the question is starting to come back again. And people are asking, as we're drafting our plan documents and as we're putting into place our subrogation process, what should we be doing to maximize enforcement of our rights?
Did someone really ask this question, or did Ron make up this question so that he could talk?
I think it's going to be neither. I think somebody threw this in there as a bone for me.
Okay.
Ron actually asked the question.
Yeah, Ron asked the question anonymously. Good.
Somebody threw me a biscuit.
All right, let's get to it, Ron, before I get people yelling at us.
So basically, what you have to watch out for, and unfortunately there is an attitude out there that if you put something in writing, right, it's a contract, and you get somebody to sign off, it feels good. It feels like a security blanket that you have it in writing and it's signed. But what people don't necessarily understand is, not just with subrogation, but your plan document in general, you enforce the rights set forth in your plan document in federal court under ERISA. Contracts are enforced in state court under state law. So if you basically go and rely on a contract to enforce your rights instead of the plan language and ERISA, you're actually limiting your rights to recoup the funds, and you're actually putting into place state rules that you'd rather avoid. So that's actually one of the reasons why in the past we've pushed against signed subro agreements, because the argument has been that signed subro agreement basically replaces the plan language and is enforced in state courts.
Right, so if your state law rights are weaker than your ERISA rights, which typically they are, you were stupid to actually have a signed subrogation agreement outside of the terms.
Stupid or misinformed. We'll go with that. But no, yeah, you're absolutely right. So
we've been saying it for 20 years.
So when people are coming in and saying, can we do contract and equity, I would tell you no, again, because you don't want to give the opposition anything that they can use to try and argue that state laws apply. So that's the positive, right? Now, what about the negative? Okay, so now we're enforcing our right in equity based on the plan language, not a signed contract. Awesome, federal court, way to go. Easy peasy, right? Not so fast. Enforcing your rights in federal court under equity instead of state court under a contract is good from a rights perspective, but it's also much more complicated and difficult to do. A contract is pretty simple. You just enforce the terms of the contract. Equity, you actually need to argue your rights, what rules apply, fairness. So because there's not some concrete term, you need to make an argument based on not only what the plan language says, but also what equity would require. So what am I saying? That arguing your rights in federal court under ERISA provides you with greater rights, but it's also more difficult to do. So at the end of the day, Adam, not only do you want to rely on plan language and equity instead of a contract, you also need to make sure that you have a team either on hand or on call that can argue those rights in equity in federal court. So you need an expert. So we're going to now talk about a little bit more FAQs. And again, it's me, Michigan. So
you're the expert.
I'm the expert on, I will, on a scale of 1 to 10, I'm at least a 2. So
this one right here is crazy. I mean, this to me is, if you're a self-funded employer in Michigan, I mean, this is bad news for you.
It could be. It's interesting. Michigan, for as long as I can remember, has had one of the most robust no-fault insurance policy requirements by law. It was unlimited no-fault. And so if you were a benefit plan in Michigan, you were more or less, depending on the fact that this person is going to have a lot of their out-of-pockets and medical expenses covered under no-fault, which really leaves very little for you to pay. And what they've recently passed in Michigan now is this rule that you can still obtain unlimited no-fault, but in order to reduce the costs, you can actually opt to put a cap on your personal injury protection and your no-fault on your auto insurance policy in Michigan. $500,000, $250,000, or even $50,000. And this is going to depend on what? If you have other coverage in place.
Right, so for most people,
your health benefits.
Again, I know there are other, optional plans you can buy, but for most people, that means if you have health insurance.
Mm-hmm. Yes. So more or less, the auto insurance industry is passing the buck onto you, my listeners.
So the auto insurance industry, I'm assuming in Michigan, has a pretty big lobby.
Yeah, I'm going to say maybe. I'm surprised.
They make the cars.
Yeah.
So they're saying is, hey, to lower the overall cost of auto insurance and to have less risk on the auto carriers, and you have a max, right?
Yep.
At least here, they know that if you're a health plan, there is no maximum. You can keep billing.
Right.
There's no limit. So what do we think is going to happen here?
So here's the deal. I think, and again, what is this very synonymous to? Workers' compensation. So from a coordination of benefits and subrogation perspective, look at this very similar to workers' compensation. And you, as a benefit plan, particularly a self-funded benefit plan, you have the opportunity to adjust the way your plan approaches auto insurance claims the same way you approach workers' compensation claims. We, as you know, draft many different plan documents. We have template language. We have our PDM program. We also do revision work on existing plan documents. And often what we'll do is, and Adam, you talk about this all the time, there's like 50 different options when it comes to the workers' compensation exclusion.
Right, also for COB.
And what are we addressing? We are addressing the fact that sometimes you have a plan that will exclude claims if it arises at work, regardless of whether you have workers' compensation.
Right.
Sometimes they exclude claims if workers' comp was available, but you opted out, doesn't matter. And
or
sometimes
you didn't file a claim.
Right, and sometimes it only excludes if not only do you have workers' comp, but it's covering it.
Right.
So
So you've actually filed a claim and it's accepted.
You can take that same mentality now and apply it here, right? You can say, we deny claims if it arises out of an auto accident, and you had the opportunity to obtain no fault, regardless of whether you actually adopted it.
Not so sure that will work, but
So
maybe that could be discussed. We can fight about that later.
So I believe what you're going to see is pushback from the plan in the form of exclusions and limiting language,
Right.
which in turn is going to require them to revisit how they're doing this and create the conflict you're talking about.
Wait a second. Does that mean there's more work for Phia because we have to change the plan doc?
You know, anytime someone changes a law, somebody's got to deal with it.
That is horrible.
It's tough to be. It's tough to be us, Adam.
But remember the effective date of this one.
Yeah, so it's not going to be until, July 2020? So, yeah, we got a little
Speaking
time.
of 2020, folks, 2020 is the 20th anniversary of Phia. So, pretty big.
You know what? That's why I got married in 2010, because it's easy to remember the year.
Very good. And Jen, are we back to you now talking about compliance?
All right, let's dig into this.
All right, ready.
Compliance.
Got my bib.
Oh, Ron. Okay, so as we are getting ready to talk about some of the things that we need to consider for 2020 outside of subro, outside of maybe modifying some of our out-of-pocket max language, let's take a look at some of the employment considerations, because as we learned over the course of the years, the plan document shouldn't stand alone without a review or consideration of any of the other documents, whether it's a network agreement, a stop loss policy, or an employee handbook, as we're coming to learn. So this year, actually the past couple of years, there have been quite a few new rules and regulations that are things that we need to consider not only here at Phia, but we want to suggest that all of you consider when you're looking to make some updates. The one that is obviously the most important that we're seeing again and again and again is the sick and family leave laws. These rules are going into place all over the country, whether it's on a city level or a state level. This is something that you need to consider as an employer, as an administrator, as a carrier, to make sure that you're adopting plan changes to cover the continuation of coverage if so required, and also making sure that you're updating your handbooks to make sure that you're allowing for the leave in the first place. Because remember, a leave is two parts. One is actually allowing the leave by the employer, and the second part is also allowing continuation of coverage by the plan. So you need to make sure that by adopting and complying with these new regulations and laws at the city-state level, that all the policies are coming together and are aligned with what it is that the employee is going to be eligible for as far as coverage and benefits are concerned. Another consideration when we're talking about these employment laws and how they're related to our handbooks and other policies are pay equity laws. These are going into effect. There's one in Massachusetts. There's one all over the place. And when we're looking at these and doing our audits for pay equity purposes, is this something as a result of this audit that you might actually need to review how your eligibility provisions are set up in your plan document, in your handbook? So consider that when you're looking at those regulations, whether the impact is actually much broader than just making an adjustment to someone's pay rate. Also minimum wage, same considerations when we're talking about the handbooks and how eligibility is defined and who is actually eligible to be an employee, full-time, part-time, what have you. Diversity, this is something that's also been big here at Phia too. There are a lot of new laws and regulations that are protecting individuals. For example, there's laws across the country about having lactation rooms and making sure that it's beyond the scope of an actual bathroom. There's a lot of these things.
Didn't we just have an email go today from Philip in regard to the staff? What was that about? in particular, you guys remember?
Massachusetts State Family Leave policy is coming up, yeah.
Right, so I mean, it ties into this. I mean, well, there's the example right there, Mass Paid Family Leave Law.
Right.
So just so people know, as many of you know, we have millions of lives currently that use our ICE service, where we act as independent consulting and evaluation of claims as part of our service to you. But based on the fact that so many of you have reached out to us with more HR-related type questions,
That's right.
you know, we've added that to the mix, where we're now, in addition to just offering those ERISA type answers relating to claims, relating to your plan design, relating to your employee handbook, because of the massive number of questions that have come in and the complexity of all this, we're now throwing into that particular service more HR-related type questions such as discrimination and so forth.
Yeah, you know, I think, Adam, once we bridge the gap between the plan and the handbook, to Jen's point, because they do have to coexist, once you bridge that gap, the amount of HR-related issues that come crossing that bridge, I think, has really surprised us, and that's why now we're addressing it more closely.
Okay. Jen?
Yeah, the last racy thing when it comes to these employment laws to consider is pretty racy, is all of these new marijuana laws, or vaping or e-cigarettes, as this is becoming legalized and more common when we're seeing people that are vaping or using e-cigarettes. How is that impacting the actual employer? Is that something that they're going to allow in their handbook? What's going to happen if they show up to work can they vape while they're at desk? There's a lot of considerations that employers need to consider and contemplate as far as their handbook is concerned and what is and is not permissible.
Are all those laws just like gray area right now? I mean,
each state has a different one. There's different rules that you have to look at. And
so for us, do we have to allow someone to vape in the office?
No.
No, we don't.
No, but our handbook.
But you guys all vaped prior to this webinar.
Well, but we were outside.
All right, so we can let them be out. They can be outside vaping. They just can't be at their desk.
You know, Brady needs to get his fruit punch smoke or whatever.
The thing about this to consider, though, is that all these laws, as they're coming to be, and different states are adopting them, our handbooks haven't been modified and changed. So if it's not specifically excluded, is that actually some sort of punishable offense by the employer? I don't know. Something to look at. Last one here. Trying to hurry me, Brady.
Right.
Is the group planning on using a new vendor or a service? So we've talked about this in the past, but now is the time to really consider this. This is something actually internally here at Phia that we're doing as well, as we're looking to adopt new benefits and new opportunities where we can contain costs for our own employees. There's a lot of consideration and planning that needs to go into that process. It shouldn't be something as easy as, let's go, let's get moving on this. You have to consider the interaction of what is actually required. Are there particular data sets that are going to be required? Is there any 105H testing that's going to need to be done in order to do this? Is there plan language that's going to need to be added to modify base to adopt a particular program or service? Is the entity that's going to be administering the medical benefits, the prescription benefits, are they going to be able to do this? Are they aware of this? Are there separate fees? So make sure that as you're going through the planning process with in mind of making a change to the benefits or adding a new program, that you're starting to have these discussions now, so you're not waiting until December 31st and then letting the entity that's administering the benefits know that you plan to make a change 1/1/20.
Well, it's funny you guys say that, because literally while this webinar is going on, as you can imagine, I still check emails, right? We received an email asking for a legal opinion on reference-based pricing vendor disclosure on Form 5500, and whether or not those fees need to be basically outlined on a 5500 form. I mean, these are all the kinds of things that we're talking about where, yes, it's a compliance issue. Yes, it's a disclosure issue. Yes, it's a vendor issue. So, and tied into your plan design. So, I mean, while this, literally we got this question prior to Jen even bringing it up, so I just thought it was time to bring it up.
I just want to know who sent that email, because they should be tuned into the webinar.
I think they should be. We'll see if they send us a text stating that they are. All right, Jen?
All right, so yeah, talking about SPDs, this is something else that we need to consider as we're getting closer to the new year. When was the last time your document was updated? Do you have an unreasonable number of amendments?
What's the biggest number of amendments you've seen?
23.
23. The last time I asked was 21. 23 amendments. How many of those amendments literally overrid each other?
Most of them. This was a group that was adding eligibility changes month after month, it seemed.
So, like, you turn page one of them and be like, yes, he'll cover it. Okay, oh, I'm not. Oh, yes, I am. Oh, no, I'm not. That's why you just keep doing it back and forth?
Jen's like an archaeologist. She keeps digging and history,
Pretty awesome. Jen?
And remember, for not making these actual updates and having these documents ready, there are penalties that can occur on a day-by-day basis for not being able to produce these documents. So If you don't feel like doing it for making sure participants know what benefits they have, make sure that you're doing this so that you don't get fined. And last but not least, as of the first day of the next plan year, is the plan going to implement a carve-out? So we've talked about this before too, just making sure that when actually you're implementing and adopting these types of programs, that you're doing it on a go-forward basis. That way there can be enough time for everyone to be on notice of the particular change. You're complying with the ERISA deadlines, the ACA deadlines, the SBC deadlines, so that there's no confusion for anybody.
Question about that, if you don't mind. What is the most popular carve-out that you see, Jen? Is it dialysis?
It is dialysis.
Is there a second that comes to mind? Or
Runner up.
Especially drugs.
Especially drugs. All right.
Yeah.
Interesting.
Yeah.
All right.
Next, you'll be eligibility audit. So this is just a reminder here that making sure the eligibility files are up to date. You don't ever want to be in a situation where someone may have been eligible for Medicare or another plan, and the plan wasn't properly coordinating the benefits, and it can result in a huge overpayment. So make sure that you're paying attention to this. Also, look at your ASA agreements to make sure there's language in here that would protect you or the plan from this. And this is exciting. So the last exciting thing.
Jen and her exciting topics.
I want to point out real quick that
Yes.
someone actually
Wait, Brady hasn't talked in 35 minutes.
There was
I want
no
to say-
political update.
Nope. Do we skip political update this month?
Purpose, right?
We'll have a big one next.
We're saving
I just want to point out that a comment asked about this particular notice, which Jen's going to get into now, so we're happy to provide the answer live on the webinar to this question.
It's like it was planned.
I mean, Zita asked this question before we brought the slide up, so really good. Jen?
Yeah, so IRS Notice 2019-45. If you haven't read it, read it. This was a July 2019 IRS notice that went into place, and this is actually a big deal. So right now there are rules specific to a high deductible health plan that the deductible has to be met before benefits that are not considered to be preventive are covered at 100%. Not a new rule, something that we're aware of. This notice is actually allowing the opportunity for a plan to pay first dollar coverage for certain things. So it's broadening the scope of what's considered to be preventive. But this is not broadening the scope of what's considered preventive under ACA. This is only broadening the scope to allow certain benefits to be considered preventive, so you don't have to have these subject to the actual deductible before the plan is actually paying. So there's a laundry list of these, and they're related generally to chronic conditions, a lot of medical terms that I don't know, but in general.
But if you want to reach out to Jen and our team, we'll gladly share with you that list, correct, Jen?
Yeah, there's not too many of those, but this is an important thing to consider, and you're going to have to make some changes to your plan documents to make sure that you can account for this to happen.
More money coming in. Sorry, yeah.
So just consider this rule, and this is not necessarily required. Remember, this is just something that is another option that a plan can consider if they have individuals that have these chronic diseases, diabetes, asthma, for example.
So that ties into that question we got from Alexa. Do they have to implement the whole list, or do they pick and choose?
You can pick and choose from my understanding. So this is just something that you're going to have to actually change your language to accommodate for, to make sure that you're not going to create any tax problems or consequences for these individuals that are enrolled in these high deductible health plans.
Just, even though we keep saying this every time, yes, the slides are always available. You can go on our website and get the slides. Is that correct, Matt? He is nodding yes. You can go on our website and get the slides, but only if you pay us a $199 fee. That's the way it's going to be. All right, Brady, we're turning it over to you finally.
Finally, I feel like Ron.
To talk, and look at the numbers dwindle. All of our numbers have dropped tremendously the minute we said Brady's coming on. Ron?
We can't talk about back to school without talking about fiduciary duties, because it's so important to refresh yourself. They're very, very
Never
important.
seen the movie.
I don't think he has any kids.
He doesn't even know
not
who Ron
seen
is.
the
All right, Jimmy, it's time to go back to
I know
school.
he's dead.
Before you do, we got to talk fiduciary duties.
Well, no, we do. It's very important to remember this, because look, we get questions all the time about, the intricacies of the fiduciary rule itself, right? What are prohibited transactions? Are my fees too high? What do I have to disclose? On and on and on. The key things to remember, and this is coming straight from the statute, by the way, itself, is that you've got to act solely in the interest of plan participants and their beneficiaries, because you're using their money. Anyone who has control or exercises discretion over plan assets is going to be considered to be a fiduciary. And if you're a fiduciary, your obligation is to protect the plan assets. And if you don't, you can be held personally liable, up to and including going to jail in certain extreme cases. So you got to make sure that you're being very careful. And there's been many, many cases in the last couple of years that have really expanded the scope of fiduciary duties. So you've got TPAs been found to have acted as fiduciaries. in certain cases, PBMs even. In fact, the administration was pushing for a rule to ensure that all PBMs were considered fiduciaries. But remember that, as you're handling claims, you got to be careful. So one case I went back and reviewed that we talked about a couple years ago, what I think is still relevant today, is that even if you have a good appeal process in place, if you're using vendors and in one case, the TPA was sort of found to be picking and choosing a medical reviewer that was giving them sort of the result that they wanted. The court found they had a conflict of interest. You got to be careful about not having a conflict of interest, doing things objectively or using experts if you feel that you can't do that in-house. Also, making sure that you're following the plan document. Of course, hopefully it's written well and you don't have ambiguous terms, because most of the TPAs and plan sponsors we see get in trouble with fiduciary breach are the ones that don't have well-written plan documents. They have ambiguous terms that they don't follow in the court's view properly, or in some worst cases, they actually ignore the plan doc. They make an exception. They cover someone that they shouldn't be covering, the CEO's son or something, or they're failing discrimination tests by excluding certain claims. You've got to make sure that you're following your plan doc as long as it's written well.
I have to cut you off for a second. I'm looking at the bottom tab, the bottom below, it says paying only reasonable plan expenses. I would love to see a case where a plan is held to a breach of fiduciary duty for overpaying on a claim, yet that claim was an in-network claim, and they have to pay that claim based on a network contract, otherwise it'd be in violation of that network contract, and be stuck with full bill charges. At that point, it would definitely be paying above the reasonable plan expense. I mean, if you're a plan, how do you do both? I don't get it. If I'm reimbursing a claim at a DRG rate, which is more than the bill charge, and we've done it here at Phia, how am I not breaching my fiduciary duty? How am I not breaching what I'm supposed to do is in the exclusive interest of plan participants? Didn't I just violate that?
I think so, Adam. I think the conflict between your contractual obligation and fiduciary obligation, issue number one, and then issue number two, you can always justify somehow the amount that you paid by arguing, well, if I didn't do that, then there'd be other expenses we'd have to deal with in the future. And I think that ultimately how you define reasonable expenses and how you get through that conundrum you just created is ultimately the question that needs to be answered.
Right. The thing to remember about fees, by the way, the last thing on fees is, as long as you're clear and you're disclosing them, because in our industry, there's so many more vendors coming up every day offering so many services, so you're probably paying a lot in fees. And that can be okay as long as you have a record of what you're paying and you can justify the savings you're getting for your plan.
And disclosing those fees.
And disclosing those fees. That's, absolutely the biggest part. But again, following the SPD, one of the hardest things we get, and most of our questions that come through consulting involve interpreting a term that is confusing, or, hey, we have this unique fact pattern. And again, the consequence of getting it wrong is potentially being found to be in fiduciary breach.
And I want to share an inside story on this. So for example, I get annoyed sometimes, even at work here, where we will ask a basic question, right? A client will ask a question. And if I ask 4 of our attorneys, 2 of them will side with one definition and 2 will side with another. We can't even get our ERISA expert attorneys to agree on what an exclusion means. So what would a typical claims examiner do or a plan sponsor do if they're reading the exact same language? I mean, we can't figure it out sometimes, right? Often.
No, absolutely.
Right. I mean, just today, we had that situation happen.
But I think that's why, for the longest time, you had a lot of deference being shown to the plan administrator as long as they're acting reasonably, because I think everyone agrees there's no hard and fast yes or no, black or white answer. The problem is, as more and more entities get involved, so the carrier, the employer, the plan, the vendor, the provider, us, and they have different opinions, ultimately the question then becomes whose deference controls and in what situation? Maybe the plan administrator's controls on the plan decision, but then does that mean the stop loss carrier's deference controls when it comes to reimbursement?
Right. And it would be key to have just a way of backing up your decision one way or the other.
So in honor of Ronnie Dangerfield, we want to make sure we bring up the opioid crisis, right, guys? I mean, I know I'm joking about it, but we obviously know it's a serious problem, not only in the country, but to many of us just personally in our families and our friends. So, Brady, what do you got here?
Yeah, and so this is talked about at many conferences industry-wide and frankly nationwide. And I wanted to introduce a different spin on this, where what's happening lately is a number of these lawsuits are being brought against drug manufacturers. Something like 1,800 lawsuits now. They're pretty much being organized into one giant class action suit. But what's going on here is you have liability potentially being established against drug manufacturers, and that could present some opportunity potentially for self-funded plans. Before I talk about the opportunity, though, just some quick facts. Everyone mostly knows them, but you've got 11.4 million people misuse prescription opioids. We all know that the overprescription of opioids has led to numbers and numbers of tragedies. 130 people died every day, roughly in 2017. So all those people who are overdosing or finding themselves addicted to opioids are they're consuming a lot of healthcare, not surprisingly, right? And these numbers are from HHS. So I want to go through them just quickly here. Look at the increase in the trend for just 12 years here. $300 million of the cost of treating addiction in 2004, $3 per person.
What?
Now up to $2.6 billion in 2016. So I mean, not surprisingly, 40% of people are addicted to opioids and are covered by health insurance. And because the problem has gotten that much worse, so has the spending.
So 40% of the people that are addicted to opioids are covered by private health insurance, which is unlimited benefit. Is that why we see all these commercials on TV now showing these resort-style rehabs, rehabilitation centers or recovery centers?
Yeah, I mean, well, when you saw mental health parity come out, you saw a lot of advertisements for mental care. I believe in Louisiana and some other states where if the plan pays any kind of benefits for weight loss, it has to cover everything. And so you see a lot of the surgeries for lap bands and things like that being advertised there. So absolutely, Adam, they know what they're doing.
Hey, really quick, so keep getting this question, even though I thought we just answered it. Go to our website, phiagroup.com, go to media. Under media, the top bullet is webinars, and you'll see the back to school webinar slides right there, as well as literally going back for years. If you want to hear what Ron's voice sounded like when he was 30, you can dial in and watch. Okay, next slide, Brady.
So the takeaway here is I think we're going to keep watching these cases, especially in Ohio. There's a lot of concentrated ones there. But basically, a lot of workers are suing manufacturers, and they want to recover the costs that they paid for both the prescriptions themselves, for the treatment itself, and other secondary injuries that may have resulted. So obviously for self-funded health plans who may have employees who are addicted and getting treatment, there could be opportunity for them to recover money as well if liability is established against these manufacturers. I think going forward from here on out, I think this will be a louder and louder sort of noise that we hear, and more opportunity will emerge for self-funded plans.
So subrogation again, Brady? It keeps coming up. I love it.
Yeah, it's a big deal. So we'll keep our eye on it.
Awesome. Well, thanks, Brady. So real quick, let's quickly just go over stop-loss policies. You know, as we're on the road talking to people.
As we're in renewal season.
In renewal season, there are many people out there who have been in the stop-loss game or the self-funded game for many, many, many years, and they understand the difference between different stop-loss contracts. However, as you know, self-funded is growing, and as self-funding is growing, the number of people who are first encountering stop-loss is growing as well. And they don't necessarily understand, A, the difference between stop-loss policy types, and B, what it actually means for them depending on what they choose.
So wait, are you going to explain to us, Ron, what a run-in versus a run-out is?
Well, I'm not going to spend too much time doing that, but yeah, more or less you have to determine, A, am I getting a policy that's going to pick up claims that my plan is responsible to pay from dates prior to me signing the policy? Do I have a policy that's going to pick up claims that I pay after the policy expires? Or am I going to execute a policy that only covers me from the date I sign it to the day it closes? And so basically having that run in or run out, that head or that tail on your policy is going to matter a lot. Now, here's the thing. You have to be very careful to avoid what they call the peanut butter cat situation, where you've heard that. Listen,
what?
Yes, I've heard of it.
I've never heard anyone say that in 20 years.
Here's the thing.
Wait, what did you say at the beginning that how everyone assumes you've heard what?
Oh, yeah, the peanut butter and cat situation. So here's the deal. If you drop a cat, it always lands on its feet, right?
Right.
But if you drop a peanut butter sandwich, it always lands peanut butter side down. So if you put a peanut butter sandwich, listen, yeah, and it's always a mess. So you put a peanut butter sandwich on a cat's back and drop it, it will literally hover in the air because no one knows which side should fall.
We need to add a poll question. Should we only allow Ron to talk at the end of webinars again?
I just made that up. No, but in all seriousness, so here's the problem, is that if, let's say you have a policy the year prior that has a run out, and you pick up a policy that has a run in, are those two carriers, assuming it's a different carrier, are they now going to get into a little battle over who's actually responsible to pay the claim?
Which one's not going to pay the claim?
Who's not going to pay the claim? Correct.
Yeah.
So it's not just a matter of ensuring that you have a contract which is going to cover the run-in or run-out depending on what you need, but it's also making sure that those two contracts are going to coordinate together. So it requires a lot more thought than you would think.
But the definition of paid and incurred/paid is also a big deal.
Oh, yeah, definitely.
Go over that a little bit, Ron.
So, again, and remember, you get what you pay for. With paid, you know, you're looking for that policy that's more or less going to cover anything your plan has been responsible to pay. What you're finding is for a lot of those who are first entering the self-funded field and they don't know what they need, they're looking for something that's going to pretty much cover anything they're ever responsible to pay. Whereas the 1212, where it's, again, starts with the policy year, ends with the policy year.
So, as an example, I'm hurt on December 31st. Oh, wait a second. That's actually the comment.
Oh, how did you know? So,
Well, here's what we see. I fall down, not because I was drinking. I just fall, because I'm clumsy on December 31st.
Happy New Year's.
How would it be possible for me to have it, it's incurred December 31st, but how in the world could that claim also be paid on December 31st?
Adam, there are apparently a lot of third-party administrators that are very confident that the provider is going to submit the bill to them within minutes of treatment, that they're going to process the claim within minutes of getting it.
And that's not, that wouldn't be auto adjudication.
Oh, no, sir. And they're going to get the checks in the mail and sent to the provider before the new year tolls.
So basically, a 1212 really means it's incurred, it's really like a 9-9 or a 9-12.
You want to give yourself some buffer.
Right.
That makes a lot of sense. That's a good way of
12 is really a 9-12.
That's a good way of looking at it.
3 months for that whole process.
Correct. And and one of the big issues, and we've talked about this in the past, is the definition of paid under the stop loss policy, where even if you get those claims right after treatment, and even if you get them paid right after, if you literally send payment through some sort of a clearinghouse, and all you're doing is issuing instructions to the clearinghouse to send the check, you're relying on that third-party vendor to mail it in time, and more often than not, it's not going to go out until the next.
Do we see a lot? I mean, folks, please feel free to comment to us. But do we see a lot of 1212s really? No, right? No. Because 1212s, I would assume that everyone has a problem eventually.
You make the mistake once and then you don't do it again.
I mean, do people sell it? If you're an MGU or stop loss carrier or broker, if you sell 1212s or see them on the market, please let us know.
Sure, great question.
We just don't see that many of them, right, guys? I mean, we look at a lot of stop loss policies.
I think so. I think the only place I could see it is if you are somehow guaranteeing that you're going to stay with the same carrier year after year, and they work out something with you where if it's not another one, it's going to carry to the end.
Yeah, it would carry on. Well, it wouldn't.
No, but they would have to agree to that.
That'd be
separate from the contract.
Exactly.
This is real.
Okay. Ron, keep going, bud.
All right.
You're on a roll. No peanut butter jokes.
No peanut butter. All right. So how about some cream cheese? No, I'm just kidding. So, again, one of the issues that we're seeing is sort of this idea that UNC is in the eye of the beholder, where, unfortunately, we talked about it before, there's a lot of ambiguous language that's out there. And in the past, we just relied on the fact that the plan administrator's sort of deference or discretion would determine what the word means or doesn't mean. But as more parties are involved in the claims process from a stop loss perspective or from a vendor perspective, whose definition counts and when is one of the biggest issues that we're dealing with. So when you're looking at a policy or a contract, you have to be looking for not only do they mirror my policy, do they see, are they willing to accept my language versus their own? That's issue one. But then issue two is if they do mirror my policy, will they also mirror my interpretation of that language? And that to me is, I think, more than just the language differing, which is pretty easy to spot. Whose sort of definition of that language are we going to use? That's ultimately the thing that you need to be looking for. Additionally, if you're a plan, and Adam, you brought up the point, who's the master, the PPO contract or the sort of fiduciary duty? As far as stop loss is concerned, the plan controls.
Right.
The fact that you have some third-party contract with the network, that ain't their problem.
Well, that's why you need to make sure if you have a PPO contract or a network contract that you feel has a priority in your stop loss policy, in the comment section, you better make sure you put a note in there that says the same. Hey, just speaking of, so people have been reaching out to us, and 1212s are definitely sold still. Guess what, Ron? They all focus on the fact that with an expectation of renewal.
There you go.
So it definitely makes, I can see that way. It's almost
like we know what we're talking about. So,
sort of.
Yeah, and so this is just the example that we frequently see where you do have a plan that's stuck between a rock and a hard place, where they either pay what, the stop loss would indicate that they should be paying, the lesser amount, and now you breach your network contract, or you pay what the network contract requires, and now you're stuck with an angry carrier. So again, how do you resolve the situation? Frankly, it's very difficult to do after the fact. You need to do a review of your policy, your plan document, network contracts, all up front, gap-free review. So there you go.
Now we're going back to Jen. Watch the numbers fly up again. Wow, amazing. Jen, take it over. PBMs.
All right, PBMs.
What are we seeing?
I'm sure that no one has any experience from this past year with having some high RX costs, right? That's not a problem with drugs.
Nope.
Nope, not at all.
Everything's cheap, everything's free,
Just take some aspirin, you'll be okay.
right?
So just like we're talking about finding ways to contain medical costs, have you ever actually looked at the data for your RX spend? Do you know where the money is being spent, how it's being spent? Maybe this is an opportunity as we're getting close to renewals and thinking about whether or not this is the best relationship or PBM or the best experience that we're having. Maybe review your spend. Maybe see what it is that are high costs for your particular population. Maybe there's an opportunity where you can make a cost containment suggestion to modify or to encourage certain types of behaviors. Maybe there is another opportunity there where you contain costs. But the bottom line is you're not going to know how to make changes if you don't know how your data is going to fall or what actually you're using your money for in the first place. So this is an opportunity to take a look and ask this question at renewal, how the RX breakdown spend is actually being used.
So really quick here, obviously folks, changing PBMs isn't the easiest thing in the world. However, we have seen more PBMs, what's the word I'm looking for, have the willingness to add drugs to formularies.
A little more flexibility.
There's a lot more flexibility that we're seeing, there's no question about it. And then adverse benefit terminations, Jen. What is going on there? How is this an issue?
ABD.
Yeah, ABD, that's right. The ABD, this is a big deal because we need to make sure that particularly if there's a PACE issue, for example, or in general for any compliance purposes, what is the template that you're using to deliver the message that a claim is being denied? People are starting to pay attention to this, and there are specific ERISA regulations that actually have model notices about the specific information that has to be contained within the adverse benefit determination. Such things as the explanation, why is this being denied? Is there a specific plan provision that you can point to for why this is being denied?
All right, Jen, I'm going to cut you off there for a second, okay? Here's the problem I see with this, right? And it's not a TPA's fault. It's system limitations. A claim system is only can do so much, right? Especially people that we all know, and if you're a TPA in this call, you're nodding your head right now, claim system conversions. I mean, anyone that converts over to a new claim system probably loses clients. Because it's painful, it's a lot of work, there's a lot of training, it's years of process. So making sure that your actual EO explanation of benefits can actually put all these things on it is difficult.
Well, that's the problem, is that so many try to use their EOB as the adverse benefit determination, and you're right, the EOB is such limited real estate, and you literally see exclusion verbiage now that says denied, denial reason, look at the bottom. Denied, not covered by the plan.
They do the same thing on the ABD. But they do the same thing.
So what the problem is that the rules, what they sort of envision is that you're going to send somebody a novel that explains the reason why your claim is not paid.
What is it they want, Jack? Give me an example. Is it a 2-page letter? Like, what is it?
The model notice from the DOL, guess how long it is? 4 pages, right? This is like a 3.5-page document that outlines all this relevant information about how you can appeal your rights, what it is that's being relied upon, whether there's any particular evidence that was necessary in making this decision, if there's something that, a reason why the claim couldn't be processed and has to be denied.
So you would have to put an explanation of the reason for the denial. Now it's in the plan doc, explanation. But then you would add the actual plan provision, right? So you take the copy and paste that. And then third, tell them what they have to do to try to get the claim paid.
So if there were medical records that were outstanding, for example, additional information is necessary. Those are the types of things that need to, you don't have to actually add in there if you were relying on a max allowable charge as the exclusion. You don't have to have the 4-page plan provision specifically, but just the reference to the actual plan provision that was being used in the first place.
So I don't want people to freak out, Adam. One of the best practices that we've seen to kind of split the baby and meet it down the line is
call Phia?
Yeah, well, there you go, right? And what we've actually been able to do is, depending on the way your plan language is written and the way your EOBs look, is the EOB will actually refer to the plan, so that if you're the plan participant and you get this EOB, it'll indicate denied illegal act exclusion, see page blank. This way, you're now referring to where there's more robust verbiage.
Folks, that's all the time we have for today. Thanks for the great questions, the great comments. Fact is, most of you want us to be funny. You want us to continue to make fun of Brady, so we will continue to do that at no cost to you. Folks, our next webinar is September 17th. Guess what, folks? At that point in time, mark my words, the Cleveland Browns will be 2-0. The New England Patriots will be 0-2. That is my forecast. That is my prediction. We'll see if I'm correct. It might be the exact opposite. Probably will be. Spinning around it. The exact opposite. Folks, on behalf of Jen McCormick, Brady Bizzarro, my man, the best, the #1 guy in our industry, Ron E. Peck, and myself, your humble servant, Adam Russo, Thank you so much for joining us today. We'll see you in the fall. Have a great one.